Data privacy breach. Airlines and banks sued over secret sale of passenger information to federal agencies. A major legal battle has emerged involving the intersection of travel, finance, and government surveillance. A proposed class action lawsuit has been filed against TD Bank and the Airlines Reporting Corporation (ARC), alleging that they bypassed legal protections to provide federal agencies with unprecedented access to private passenger data. The Travel Intelligence Program, at the heart of the controversy, is ARC, a company that facilitates financial settlements between airlines and travel agencies. ARC processes approximately $100 billion in travel bookings annually, creating a massive, real-time database of ticket purchases. According to the lawsuit, ARC operated a travel intelligence program that allowed various government entities, including the IRS, FBI, Department of Homeland Security, ATF, SEC, and TSA to search a database containing over 1 billion records. This was not a limited search. Agencies could reportedly query information by passenger name, travel itineraries, fare details, payment methods, credit card numbers, and end run around legal protections under normal circumstances. The federal government cannot simply browse a citizen's private financial life. To access sensitive information, agencies are generally required to follow strict legal protocols, such as obtaining a search warrant, a judicial subpoena, or a formal administrative subpoena. The lawsuit argues that the sale of this data was a deliberate attempt to circumvent these protections through two primary legal frameworks: the Right to Financial Privacy Act. This law prohibits financial institutions from sharing a customer's records with the government without authorization or a legal mandate. Crucially, the law protects information derived from a financial record. The plaintiffs argue that, because airfare purchases are linked to credit cards, the data sold by ARC constitutes protected financial information. The Gramm-Leach-Bliley Act. This act requires financial institutions to be transparent about how they share non-public personal information and provides consumers with the right to opt out of such sharing. The lawsuit contends that providing direct, searchable access to the government fell far outside what consumers were led to expect. The legal gray area: who is responsible? The central challenge of this lawsuit lies in a complex technical and legal distinction. Who actually held the data? The government's defense will likely hinge on the fact that they did not ask TD Bank for records. Instead, they purchased reports from ARC, a commercial entity. This creates a significant legal question. Is the data bank-derived or travel industry transaction data? The argument for the plaintiffs: because the transaction stream includes payment details processed by TD Bank, the information is inherently financial and should be protected by privacy laws. The argument for the defendants: ARC is a commercial data provider, not a bank. Therefore, the data they sell is a commercial product, not a private bank record subject to the Right to Financial Privacy Act. Why this matters: this case highlights a growing trend where private corporations act as data brokers for the state. By transforming private transactions into searchable commercial databases, companies can create a backdoor for government surveillance that avoids the traditional oversight of the judicial system. If the courts rule that commercial databases containing payment-linked travel data are subject to financial privacy laws, it will set a massive precedent for how much information corporations can legally sell to the government. Conclusion: the lawsuit seeks to determine whether the sale of travel and payment data was a legitimate commercial transaction or an illegal workaround designed to grant the government warrantless access to private citizens' lives.